Hi, I'm firearms attorney Gilbert Ambler, and I'm here today to talk about 80% firearms or personally made firearms. And there's been a lot of buzz about 80% firearms this week because, as most of you probably know, Judge OConnor in the Fifth Circuit vacated the ATF's final rule which redefined frames or receivers. We're going to talk about what that decision says and what are some of the possibilities moving forwards. Before we dive into this subject, if you have not yet hit subscribe, go ahead, hit subscribe for us. Like, comment with your thoughts, share. That way you and your friends can keep getting this important Second Amendment related content. All right, Judge OConnor did a couple of things all at once. He granted the motions of JSD Supply and Polymer 80 to intervene in Vanderstoke v. Garland. He then vacated the final rule. And in vacating the final rule, he declined. He said, we're not going to address the constitutional arguments here. And that's pretty standard for judges. There's a principle in law called constitutional avoidance, which Judge OConnor employed to say, when there are statutory grounds that I can decide this on, I'm not going to talk about the constitutional issues. So a little bit disappointing not to get a constitutional-based decision, but not necessarily surprising. In addressing the statutory components upon which he decided that the rule was invalid, Judge OConnor said that what was fatal to the ATF, what destroyed their case, was that they concede that their new definitions of frame or receiver applied to things that are not yet frames or receivers, but are readily convertible or restorable to become a frame or receiver. And what Judge OConnor said was the ATF has clear authority from Congress to regulate and to enforce, and in fact, to make up definitions for frames or receivers. Congress has given that authority to the ATF to define frames or receivers. But because ATF admitted that they were applying their new rule to things that were not yet frames or receivers, but could someday become frames or receivers, Judge OConnor said Congress did not give you that authority, and therefore this final rule goes a step too far. So what are the paths forwards for the ATF? Well, one path forwards that they could take is to appeal this case up through the Fifth Circuit. It's very possible that they do that because we know that the Biden administration wants to keep pushing firearms laws, and they don't want losses like this stacking up against them. However, if I were the ATF, I would think this is a pretty difficult spot because the Fifth Circuit has not proven to be a friendly place to the ATF. We've seen what they recently did to the bump stock rule in Cargill v. Garland. We've seen what they seem to be doing, and it's ongoing, with the pistol brace rule. So Fifth Circuit, not a great place for the ATF to litigate. So it's possible that instead of appealing this ruling that vacated their final rule, that the ATF might instead go back to the drawing board, rewrite a new final rule on frames or receivers, and simply, when they rewrite it, claim that Polymer 80 type pistols, unfinished frames or receivers that have not yet met the stage of manufacture that they currently are calling them frames or receivers, they might simply try to rewrite the rules so that they could currently call them frames or receivers. Because if they could expand their definition of frame or receiver in such a way that it did not apply to things that they said had not yet met that point of manufacture, but in fact said at the point of manufacture at which they are currently being sold, they currently meet the definition of frame or receiver. If they were able to write it that way, then I think Judge OConnor would have likely ruled differently. So they may go back to the drawing board and start again on this. That's another possibility. Now, interestingly enough, in the same week in which Judge OConnor vacated this final rule from the ATF, JSD Supply and Polymer 80 got sued in state court up in Philadelphia, with Philadelphia and the Giffords Advocacy Group Against Firearms joining together to sue JSD Supply and Polymer 80. And in that suit, Philadelphia is arguing that there is a nuisance component as well as a negligence component because they claim that what JSD supplies and what Polymer 80 supplies, remember, unfinished frames or receivers, are in fact firearms. So what Philadelphia is arguing, they're arguing that under state law, not federal law. The reason this particular lawsuit is interesting is because my office has been litigating on behalf of Gun Owners of America a different lawsuit against the city of Philadelphia, in which the city of Philadelphia tried to outlaw people making their own firearms, including making their own firearms from an unfinished frame or receiver. And the interesting thing is that in that case, the case my office has been handling, Philadelphia has been arguing that unfinished frames or receivers can be regulated because the Constitution shouldn't apply to them, in Philadelphia's view, because they are not yet firearms. So very, very interesting. In our case, they're arguing unfinished frames or receivers, not yet firearms. In the case that they just filed, they're arguing that they are firearms. These two legal theories seem to be directly opposed. We'll see what the court does with this. If you enjoyed this content, go ahead, hit like, hit subscribe. Until next time.